Almost a month now, we've covered the awful tragedy of Keaira Bennefield of Buffalo, murdered in front of her 3 children. Police and prosecutors say her estranged husband Adam pulled the trigger just a day after he got out of jail for a previous assault on her. It has sparked a very intense debate over bail reform and the role it may have played in her death. You'll remember when Adam Bennefield was previously arrested, he only faced misdemeanor charges, preventing the judge from setting bail. Opponents of bail reform say the judge should have been allowed to set bail to keep him behind bars. But our nonprofit partners at Investigative-Post have spoken with quite a few attorneys and legal experts around the area who say the real issue here is with the charges that were brought against him by police and prosecutors. They say this case highlights shortcomings in how so many different domestic violence cases are treated. Jeff Kelly is the reporter with Investigative-Post who wrote that article, and he joins me now live. So Jeff, I know that you talked with a half-dozen attorneys here, including this UB Law School expert who is a former prosecutor. What is their case here on how bail reform really is not to blame for this horrible situation?
Well, what UB Law Professor Judith Olin, a former prosecutor with the Erie County District Attorney's Office, told me is that, in fact, Cheektowaga Police and the Erie County District Attorney could have charged Adam Bennefield with at least two felonies that were bail eligible. And what she said to me is that it's not uncommon in domestic violence cases for offenders to be undercharged, for police not to take as seriously those incidents as they might take assaults in other contexts.
Erie County District Attorney John Flynn, we see him right there, has directly sort of addressed this accusation that he didn't appropriately charge this case. Let's listen here to what he said a couple of weeks ago about this.
They're basically advocating that we fabricate evidence and fabricate charges in order to make it a felony, so this guy could have been held on bail on the original charges. We don't do that. We can't charge on optics. The optics are bad. The optics are awful, but the evidence needs to be there to the victim to elevate the crime.
So Jeff, the DA there is saying that he just didn't have evidence to charge here, and he keeps going back to the injuries to the victim and the type of assault charge that he could have filed here. But these attorneys tell you it's not so much about those physical assault charges, right? It's about a couple of other felony charges.
Yeah. So what he's talking about is assault, and for it to be felony assault, there has to be evidence of physical injury, and she apparently wasn't hurt, or at least could not demonstrate injury. However, what these other attorneys talked to me about was felony sexual assault, which Keaira Bennefield described in her statements to police. She also described unlawful imprisonment at a level that included threats of violence, fear for her physical safety, and that would justify a felony charge of unlawful imprisonment. That's what these experts told me.
And again, both of those charges would have allowed the judge in this case to set bail. In your article here, I know those legal experts say, and you touched on this, that this kind of undercharging happens all the time in domestic violence cases. What is the theory behind that?
Well, Judith Olin, who runs the Family Violence Clinic at UB Law School, offered me some studies that demonstrate that there is a sort of implicit bias in the way law enforcement treats domestic violence cases, incidents. And she said, that needs to be addressed, that needs to be changed through education and training. She also thinks that she thinks that New York State bail reform needs revision, and one of the revisions she would like to see is that domestic violence charges, even if they're misdemeanors, should be bail eligible because those kinds of incidents often escalate. And she also believes that law enforcement agencies here should adopt a sort of, it sounds terrible, but a kind of lethality checklist. When they respond to a domestic violence incident, they should sort of screen that incident to gauge how likely it is to escalate and get worse and more violent and potentially lethal.
Finally, Jeff, as we've talked about this case, because it is in the context of this broader discussion about bail reform, I mean, we have to remember that a family has been devastated here. A woman has been murdered in front of her 3 children. But when we look at the politics surrounding this and sort of the discussion about bail reform, I know you talked to someone who's been kind of studying this closely, and it seems like the type of, again, charges before the murder happened, right? These these assault charges. The judge was not able to set bail there. But even if the judge had been able to set bail, there are questions as to whether or not that would have happened even before bail reform, right?
Sure, and there have been reporters across the state who have done a great job looking at the data, and their reporting suggests that even prior to the 2019 bail reform, it's very likely that Adam Bennefield would have been released on his own recognizance, or that if the bail had been set, he might have made bail. So it's not to say that higher charges would have prevented this tragedy. It's just to say this particular case maybe is not the example of the failures of bail reform that some would like it to be.
You can, of course, go to investigative-post.org to read Jeff's full article. A lot to this. I know it's a topic very important to a lot of people, as we are seeing, crime be such an important political issue right now. Jeff, thanks so much for coming in. Have a good weekend.
It's my pleasure.